Hello, everybody. Hello, hello, hello. I was just getting ready to do our pregame show over here, and I've got some news that just came out. Bad news, not great news, but it looks like, hello, it looks like we have another emergency motion for a temporary restraining order, and there has been another group of people who have been sent using the Alien Enemies Act to South Sudan. There's also some question of one person, I think, being sent to Vietnam. This isn't confirmed. These are filings that have just happened now. So I did print the plaintiff's emergency motion for a temporary restraining order here, again, in place. This is out of Massachusetts. The judge had already put a restraining order in place. And then we have the defendant's opposition to their restraining order. So, we should probably go through some of that stuff. Hello. Hi, Nancy. Hello, Willie B. Welcome in. So this has just happened. This has just happened within, I don't know, the last hour, I think. Hello, Thomas. Welcome. Hello, G-Jack. Oh, my goodness, everybody. Oh. I mean, I don't have all the details. I haven't read the filings yet, so we'll kind of go through those together and see what's going on here. So the judge has not issued an order as of the time that I've sat down here. The most recent update was this that was just filed, and I think this was filed maybe just half an hour ago. Right, willy-nilly, exactly. Oh, thank you so much, Voluptuous Velvet. We're feeling lemony today. All right, what should we call this now? Another group, due process denied, or what should we call this? I'm not sure. Oh my gosh, how about people sent to South Sudan? In Alien Enemies Act violation. Let's see. Sent to South Sudan, which of course has some problems going on, some problems. So this is kind of a emergency motion. All right, here we go. I think we've got all the pieces there. And then today's date, so 5/20. All right, there we go. Hello. Can the DOJ revoke a green card without reason? Great question, and I do not know the answer to that. A green card is legal paperwork, right, that allows people to be in the United States. So, you have a legal document that allows you to be here in the form of a green card. Whether or not those green cards can be pulled, I do not know the answer to that right now. I'm not sure it's the Department of Justice. I think the DHS can make those decisions under the Alien Enemies Act. I think it's the Secretary of State. So, I'm not really sure how that process works. And again, because the rules are kind of weird right now because they're not being followed. So I would say a revocation without any reason is not okay, but what they would say is that they have a reason, and then they're not going to tell anybody what that reason is. So unfortunately, I just don't have a good solid answer for you on that one. Just got started now, Stephanie. Just got started. All right, notepad. Yes, I was just thinking about that. Well, now Blue Horizon, I'm glad you asked. So I had planned to go over to the Tube tonight. I was supposed to head over there at 8 o'clock Central, but this is breaking news. So this is breaking news. So I do want to go through the petition for the emergency preliminary injunction just filed, and then the answer just filed, because this is the next pillar here. This is the next huge situation. We're in huge trouble here, everybody. This is the El Salvador situation over again after they were told to not do El Salvador. So, like, if you don't do due process, you're going to be in trouble. And there's no due process going on here. Yeah, breaking news. Breaking news here. So, I want to take you through again the plaintiff's emergency motion, and then I will take you through the government's response. So this case here, the DVD case, I've discussed before. This is the case where a whole bunch of people are saying, I don't think you should be sending us to third countries. It's our home country, or, here or our home country, not some random third country. And that's what this lawsuit's about. So everything is supposed to be paused while they work out the litigation and determine whether or not it's constitutional or allowable to send, to deport people to a third country, right? So, and keep in mind, deportation is a civil situation, not criminal. We have different rules that apply in our civil cases. There's not a criminal law that's being violated in these cases. So, we have criminal cases filed for criminal cases, and this is a civil case. In this civil case, the deportation, again, had been put on hold for everybody part of this class. Now they're saying a few people here have been taken and have been sent to South Sudan. So we're just getting this information. This is it's still warm. I just printed it. That's a great question, Jan. And that's the key here. What is the Supreme Court going to say? So this is pretty major. This is pretty major. Out of the JGG case, as well as the Garcia case, the Supreme Court's made it incredibly clear due process is required for any situation. So again, I don't have the details. As soon as I start reading, we'll learn them together. But if there's no due process here, that's a violation of two U.S. Supreme Court decisions. So yeah, it's kind of a big deal. All right, let me go ahead and get started. I see we've got a lot of moderators in here. And to my moderators, thank you so much. Feel free to just mute. We've got new regulations coming down here on the talk tomorrow that will affect the lives. They're being very careful. They're not being careful. They're being extra attentive to lives right now. So I will be very careful with my language so that I'm not saying any words that'll trigger anything, but just kind of keep that in mind. So if you are making comments, everyone, just be careful with your comments, especially with the emojis. Those are, for some reason, triggering the bots. Make comments, but just, be careful so that you don't have to worry about getting dinged either. All right, here we go then. Let's go ahead and dive in. Thanks, Tay. I appreciate that. Hello, James. Welcome in. Welcome. Hi, Crimes. Great question. All right, here we go, everybody. So this is the case here. This has been an ongoing case. So today is not the first day. They're not filing a lawsuit here. They're filing for a temporary restraining order, emergency temporary restraining order. But this is the case number. If you want to pull up the full case, I have been following this case since it was filed. So it's been a couple months now. Here we go. We've got the plaintiff's emergency motion for a temporary restraining order and preliminary injunction on behalf of class members. And then they're specifying the people in the class, all right? So there's so many people included, but they're referring to NM and TTP and all others similarly situated, all right? So these are the two plaintiffs that we'll be focusing on here. Again, this is the plaintiff's petition for that emergency assistance. All right. Introduction. Plaintiffs seek an emergency order enjoining defendants from effectuating the removal of class members NM and TTP and any other class member to South Sudan because prior to making them board a plane for removal to that country, defendants failed to comply with this court's preliminary injunction. Specifically, with respect to class member NM, defendants failed to provide an opportunity for him to apply for protection under the United Nations CAT as to South Sudan. On information and belief, class member TTP was denied the same opportunity. Although it should not be necessary in light of defendants' continued intransigence, plaintiffs seek also an emergency order reaffirming that defendants may not remove NM, TTP, or any other class member to a third country unless they comply with the court's preliminary injunction. Again, it's not that they can't do it. They just need to have proper due process. All right, so that's what this is about. The envelope. Yeah. All right, last night, NM's attorneys were notified that the Department of, DHS, intended to remove him to South Sudan. Exhibit 1. I have printed the exhibits out, and this is the declaration of Jacqueline Brown. NM, a Burmese national with limited English proficiency, refused to sign the notice of removal to South Sudan, which was provided to him only in English. Good for him. This morning, they learned from a detention officer via an email that NM was removed this same morning to South Sudan under Exhibit F. As with the motion for a temporary restraining order that plaintiffs filed not even 2 weeks ago on May 7th, in which this court agreed ought to not be necessary, this motion should also not be required, as it blatantly defies the court's preliminary injunction to remove class members without a reasonable fear screening and a 15-day opportunity. Now, this fear screening, again, has to do with the technical pieces of the law on whether or not this particular piece would attach, all right? So that's why we're talking about that. A 15-day opportunity to submit a motion to reopen after any negative reasonable fear determinations. Earlier this morning, class counsel received notification of a second class member, TTP, a national of Vietnam, who appears to have suffered the same fate as NM, as well as the information that there were likely at least 10 other class members on the plane to South Sudan. Oh my gosh. Given that NM and TTP and other class members will be or have been removed to South Sudan in violation of the preliminary injunction, plaintiffs asked this court for an immediate order ordering the immediate return of any class members removed to South Sudan. The court should further restrain all flights carrying class members to South Sudan or any other third country until defendants provide the court and class counsel with evidence that defendants have complied with all terms of the preliminary injunction, including but not limited to evidence of written notices provided to class members. Again, this is what the requirements were. And the Supreme Court, right, had said you have to have due process. So written notices provided to the class members and their counsel, if any, in their native language. Written notice provided to class members and their counsel, if any, on how to request and obtain a reasonable fear screening, notice of outcome of reasonable fear determinations, and evidence documenting the 15 days have elapsed after any negative reasonable fear determination, which the class members could file a motion to reopen with the immigration court. So these are the elements needed. Written notice here in their native language, a written notice on how to request a reasonable fear screening, notice of outcome of that determination, and evidence documenting 15 days had passed. So there are 4 pieces that have to be met under the preliminary injunction, and if you meet those pieces, then off they go. But if you don't, then you're in violation of the court order, and that's pretty major. This is pretty major, everybody. This is a pretty major situation. As evidenced by the attached exhibits, class counsel sent defendants' counsel 2 emails today informing them of the identities of NM and PPT and informing them of the instant motion. Here, so again, I do have the exhibits that I have printed. Here, let me make sure I've got those up and ready to go here. Let me double check and see. I think think I'll take just a minute and go reprint those. I think those are very important to have here. Okay, and we do have a new minute order that has just been put on the docket. It looks like the judge is calling for a hearing tomorrow at 11 a.m. East Coast time. All right, that has just been added to the docket now. Here, let me go grab the exhibits. Okay, all of these exhibits, by the way, are all available online. They were filed with the plaintiff's memorandum here, requesting this emergency restraining order and temporary injunction. All right, so if you want to pull it up yourself, it is available all online here. And there we go. Oh yes, I am so thankful for this support, everybody. I was able to get a laser color printer so that we could print quick. I'm very thankful for that. All right, let's go ahead and take a minute here and go through the exhibit so we have some idea of what they're referring to as I go through the facts. Okay, so here we go. Authenticating declaration of Miss Madrid here. And just a friendly reminder, declarations mean that they're swearing that this is true. But you can swear the information is true as much as you want. It doesn't mean we've got any kind of corroboration. So this isn't any, so keep that in mind when you're looking at declarations or affidavits of those things. They have to swear that they're telling the truth, but that's pretty much it. All right, here we go. First declaration, document 112-3. So Ms. Madrid declares under penalty of perjury, which would be a minimum 5 years prison criminally, that the statements that follow are true and correct to the best of my knowledge and belief. Number one, I'm a staff attorney at the Northwest Immigration Rights Project. I'm one of the counsel for plaintiffs and class members in the above caption case. Yes, thank you everybody for the support. I really, truly do appreciate it. Especially, my gosh, the toner, everybody. I submit this declaration in support of plaintiff's emergency motion for temporary restraining order on behalf of class members removed to South Sudan. I have personal knowledge of the facts set forth herein, and if called as a witness, I could and would testify completely as set forth below. Enclosed as Exhibit A is a true and correct copy of an email I received from class member TTP's partner seeking help regarding TTP's removal to a third country. All right. Okay. And then we'll flip and we've got the email here. Right. And, everybody, seriously, these days, there's no reason why you can't go to the source document itself. Like, you don't have to rely on the media. You can go directly to the documents. That's so important. These days, it's just so incredibly important. Here we go. Here's the email. So today, hi, Glenda. I believe my husband and 10 other individuals that were sent to the Port Isabel Detention Center in Los Fresnos, Texas, were deported to South Africa or Sudan early this morning. Yesterday, ICE gathered them together and told them that ICE, intended to send them all to South Africa, and everyone refused to sign the document presented. Later, ICE came back and said they were going to send them to Sudan instead. Sounds like it was well organized. I checked the ICE detainee locator, and my husband and another person from his group are no longer in the system. I called my husband's ICE officer and was told he'd been booked out, but the officer didn't know where he was sent. The order of removal signed by a judge is to deport my husband back to his country of origin, Vietnam, not to another third country. The detention centers are overcrowded with inhumane conditions, and ICE is sending people anywhere they can to combat the overcrowding. This is not right. I fear that my husband and his group, which consists of people from Laos, Thailand, Pakistan, Korea, and Mexico, are being sent to South Africa or Sudan against their will. Please help. They cannot be allowed to do this. This is not the first. It won't be the last. If they keep getting away with it, I'm begging for your assistance. All right, so that's the email here. Let me go grab the other exhibit real quick. All right, let me get these back in order. Here we go. All right, next up here. Oh my gosh. All right, page 2, 3, 4. All right, then we have document 112-1. So this is document 112-3. There's also one talking about the conditions in the Sudan, in South Sudan, but I'm not going to read through that on this live, but that is available if you pull this up online yourself. Here we go. Oh my gosh. Man, I tell you, this administration, that's something else. This is Marco Rubio right here. This is Mr. Rubio, who can be charged criminally for his acts. And then you say, well, he could get some kind of a pardon, and that's true. But, you could also wait and file against him later on. All right, here we go. Declaration of Jacqueline Brown here. All right, so this is the second declaration. I, Jacqueline Brown, hereby declare as follows. I'm the Director and Associate Professor, Immigration and Deportation Defense Clinic, University of San Francisco School of Law in San Francisco, California. That's a long name. As well as the Legal Director of the Sonoma Secure Families Collaborative in Healdsburg, California. I make this declaration in support of plaintiff's emergency motion for temporary restraining order and preliminary injunction. I have personal knowledge of the matters stated herein. Yes, right, Karma, quite right. I represent NM, who's the person identified in the email correspondence attached here too. NM is from Myanmar. I'm always saying that name of that country incorrectly. I apologize. And they have a really cool flag too, so I feel double bad about it. apologies. He has a final removal order from Omaha, Nebraska, issued in August of 2023. NM is a member of a certified class in this lawsuit, so the DVD lawsuit. He was one of the men whom the DHS previously attempted to deport to Libya on May 7th. So it looks like the Libya deportation didn't work out. My representation of NM began after he was initially informed by DHS that he would be deported to Libya. I, along with a group of other attorneys, agreed to take on representation of the Libya group because one of those attorneys, Mr. Ryan's based in Texas, he filed a notice of appearance on behalf of the men so that he could meet with them in person. Mr. Ryan met with NM on Friday, May 16th. At that meeting, Mr. Ryan explained to NM my willingness to represent him pro bono, and he agreed. Mr. Ryan has told me that NM has limited English proficiency and that his best language is Karen. Mr. Ryan also told me that he explained to the group that they had the right to express a fear of return to a third country. On May 17th at 4:49 p.m., Mr. Ryan received a notification via ICE's e-file portal that NM had been transferred from the South Texas Detention Center to the Port Isabel Detention Center in Port Isabel, Texas, May 19th. At 4:44, Mr. Ryan received an email from a supervisory detention and deportations officer at the Harlington Field Office, Port Isabel Detention Center, providing a document that the officer alleged had been served on NM. The document stated that it was a notice of removal to inform NM that ICE intended to remove him to South Africa. The certificate of service stated that the contents of the notice were read to NM in English without an interpreter at 10:59, and that NM refused to sign the document. Mr. Ryan has informed me that approximately 10 minutes later, after he received notification that the sender sought to recall the email message attaching the notice of removal to South Africa. So sender tried to recall. Again, the level of professionalism is overwhelming. Later that day at 6:35 p.m., Mr. Ryan received a second email from the supervisory detention and deportation officer with a document that the officer alleged had been served on NM. The attachment, utilizing the same form as was used for the notice for South Africa, stated that it was a notice of removal to inform NM that ICE intended to remove him to South Sudan. The certificate of service stated that the contents of the notice were read to NM in English without an interpreter at 17:48, and that NM refused to sign the document. On the evening of May 19th, I contacted plaintiff's counsel to inform them that NM received the notice of removal to South Sudan. At that point, I had scheduled a video meeting with NM at 9 a.m. the next day, May 20th, which would be today. I will pause for a moment, everybody, and let you know if for some reason this live goes down, I will hop over to the tube to finish going through these documents tonight. All right, the tube has my same handle that I have over here. So just to give you a heads up, I have had my lives taken down before. Hopefully it will not go down tonight, but if it does, just follow me over there. Today I checked the online ICE detainee locator and saw that NM was no longer in the ICE detainee locator. I then emailed the Port Isabel Detention Center law visit email address to confirm whether NM was located at the facility. At 8:27 a.m. Pacific at Port Isabel Detention Center, detention officer responded that NM had been removed this morning. I emailed to ask which country NM was removed. The officer responded that at 8:36 a.m. South Sudan. I declare under penalty of perjury the foregoing statement is true and correct to the best of my own personal knowledge. Executed this 20th day of May in San Francisco, California. All right, so there's that. Again, this is another exhibit. You can find this online yourself too. Here's the case number. And let's just take a look and see what she has attached. So we have good afternoon. This is May 19th, 4:44. Email intended to notify the law office of the attached document served to your client here. And let's look at the document. Notice of removal. This letter is to inform you that U.S. Immigration, so ICE, intends to remove you too. This is the form that they had shown him to South Africa. So I'm certifying here that it was read in English and the person refused to sign it. All right, here's the ICE official and here's the date, time of service. All right. And next, there is the email saying that they want to recall the message. So the service of documents, they're trying to recall that. Next, we have another good afternoon. Again, notifications, same language of their client here. And next, we've got South Sudan here. And again, they refuse to sign it. Here's the date here in the ICE official. All right, and then she had sent, or there was a meeting with client here. South Sudan is what's being discussed. Here, which country again? They said he was removed this morning as she's trying to find out where he is. And again, they're saying he was removed this morning. Can you confirm he's still in Port Isabel? He's no longer in the detainee locator. So again, this person is trying to locate the person she's representing here. And then we've got this response now. Good evening. Wanted to let you know that this person received notice today, which he refused to sign, and is attached that he would be sent to South Sudan. Email was sent to this person because he's filed his G28 first and visited the whole group in person last week. This person was moved this weekend to Port Isabel. I'm meeting with him on Wednesday, 9 a.m. video, and notice came from here. I will respond to the email requesting an RFI, but if there's anything else I should be stating at this point, question mark. And then signed. So that is the second exhibit attached to the original request for an emergency restraining order and preliminary injunction here. All right, so those are the two of the three exhibits that are listed there. Okay. Well, let me just move these out of the way here. So, again, I had planned to go over to the Tube tonight at 8 o'clock Central. But again, this is kind of our breaking news, so I will go ahead and stay here. And hopefully everyone over there has gotten my note so that they can come back here. All right, so I've already started here on the plaintiff's motion, and we've made it through the introduction. Then we went through the 4 factors required in order to remove someone, which you could do. You could do as long as you follow the rules. If you didn't follow the rules, then you couldn't. And then now we will get into the statement of relevant facts and procedural history. Statement of relevant facts and procedural history. On March 23rd, 2025, plaintiffs filed a complaint, a motion for a temporary restraining order and preliminary injunction, and stay of administrative action, and a motion for leave to appear under a pseudonym. That's a lot of filings. On April 18th, this court granted plaintiffs' motion for class certification and a preliminary injunction. The court required defendants to provide written notice to the class member and the class member's immigration counsel if any of the third country to which the class member may be removed in the language that the class member can understand. Moreover, defendants must provide meaningful opportunity, which was incredibly important language, for the class member to raise a fear of return prior to any such removal, including the opportunity to demonstrate a reasonable fear of removal and a minimum of 15 days to move to reopen, even if the individual does not establish a reasonable fear. So again, there's this 15-day time period that's supposed to be used, and not just a couple of hours, as this was set here. May 7th, after media reports and reports from immigration attorneys indicated that defendants were seeking to deport class members to Libya and Saudi Arabia, plaintiffs filed an emergency motion for a TRO with the evidence that it had gathered by the time of the filing. After the court clarified its preliminary injunction order, plaintiffs received further information that NM was a class member, and among the 13 men, defendants attempted to deport to Libya, confirming the nationalities and dates of final removal orders for at a minimum of 11 of the men. And then we've got the declaration that I've just read from Jacqueline Brown. The men were not provided the notice and opportunity to seek cat protection required by the injunction. The men were ultimately transported back to an immigration detention center after remaining on a bus on the base's tarmac for 3 or 4 hours. Class member NM is originally from Myanmar. He speaks very limited English, and his best language is Karen. He received a final order of removal from the Omaha, Nebraska Immigration Court in August of 2023. On May 17th, Mr. Ryan, one of the immigration attorneys for NM, received a notification via ICE's e-file portal that NM had been transferred to the Port Isabel Detention Center in Texas. What does it mean to be a class member? Right. So what's happening in a lot of these AEA lawsuits is that they are becoming class actions. Now, there are a few elements that have to be met in order for groups of people to be included in a class action. They need to be similarly situated and able to be identified, those kinds of things, right? So if you think about the class action lawsuits for like the tobacco company, right? That's probably one of the most famous class actions. It's the same here. The class was set out that it was a specific group of people with the same kind of characteristics that were being targeted here that would be harmed. So people that had did not have the paperwork that they needed, and whatever other elements there were. One of the elements for the class is that the idea of moving them to another country besides their home country. So that was another one of the elements. So the class means that people that are named that they know of are included, but then also people not included. So this is the class action brought, again, regarding any immigrants who are saying, we don't want to go to a third country, right? It's either, here or home country. We don't want to go to a third country. So anyone that shares those characteristics are included in that class because that class was certified by the judge. All right. Here we go. So we're in Texas on May 19th. We do have a footnote here from the declaration, but I did go through and I just read that, so I will skip past that. On May 19th of 2025 at 4:44 Central. Oh, hydration, absolutely. Hydration is very important. Mr. Ryan received an email from Supervisory Detention and Deportation Officer at the Harlingen field office there at the detention center, providing a document that the officer alleged had been served on NM. The document stated that it was a notice of removal to inform NM that ICE intended to remove him to South Africa. The certificate of service stated that the contents of the notice were read to NM in English without an interpreter at 10:59, and that NM refused to sign the document. NM has limited English proficiency. Approximately 10 minutes later, he received a notification that the sender sought to recall the email message attaching the notice of removal to South Africa. Right? So, Harlingen. Oh, thank you so much. Then at 6:35 p.m., Ryan received a second email from the supervisory place The attachment utilizing the same form was used for the notice to South Africa, stated that it was a notice of removal to inform NM and ICE intended to remove him to South Sudan. I'm going to pause for a minute. So if South Africa didn't work and they were changing it to South Sudan, now you got to wonder, well, who's supposed to be going to South Africa then, right? So right now we're dealing with South Sudan issues, but will South Africa be the next set of people that have been moved? That's the question I've got. The certificate of service stated that the contents of the notice were read to NM in English without an interpreter at 17:48, and that NM refused to sign the document. NM has limited English proficiency. On the evening of May 19th, Ms. Brown contacted plaintiff's counsel to inform them that NM received a notice of removal to South Sudan and that she intended to meet with NM at 9 a.m. the next day. The next morning, so today, Ms. Brown emailed the port visit email address to confirm whether NM was located at the facility because he no longer appeared on the detainee locator. An officer responded saying that he had been removed this morning. She emailed to ask which country, and the officer responded South Sudan at 8:36 a.m. And if we remember, I think her meeting was supposed to be at 9 a.m., right? Does everyone remember that in the declaration? Oh my gosh. That's a great question. Willie B. We're going to have to ask each individual country this, right? And it's also like interesting the timing because there were some South Africans brought to the U.S. recently, weren't there? After learning the news of NM's counsel on the morning of May 20th, plaintiff's counsel asked defendants to request a halt to NM's deportation and or return him to the United States. And then there are those emails. Following this communication, plaintiff's counsel also received a report regarding another individual, TTP, a national of Vietnam and also likely a class member who is or was on the same flight as NM here. And then we've got attachments. 2 detainees. Yes, there you go. Thank you so much, VC. All right, here's our argument. So now we're setting out the argument here. The plaintiffs are requesting, again, this emergency motion. To obtain a temporary and preliminary injunctive relief, plaintiffs must demonstrate, 1, they're likely to succeed on the merits. 2, they're likely to suffer irreparable harm in the absence of preliminary relief. 3, the balance of equity tips in their favor. And 4, an injunction is in the public interest. And we call these the winter factors or the winter test. So if you hear that, that's what we're referring to regarding preliminary injunctions. Irreparable harm and likelihood of success are the factors that weigh the heaviest in the analysis. When the government is a party, the balance of equities and public interests merge. So those last 2 factors kind of merge together. Next, the TRO is requested to preserve the status quo and ensure the protections provided by the preliminary injunction. Thus, it does not qualify as a mandatory injunction. However, even if it were considered a mandatory injunction, plaintiffs satisfy that standard as whether a mandatory preliminary injunction should issue typically depends on the exigencies of the situation, taking into account the 4 familiar factors under the Winters test. Plaintiffs satisfy the requirements for TRO. Plaintiffs are likely to succeed on the merits of their claims. So number 1, defendants forced NM and TTP and other class members to board the removal flight to South Sudan in violation of this court's preliminary injunction. Plaintiffs are likely to prevail on their allegations that defendants' flights removing class members NM and TTP and likely other class members violate the court's PI as defendants at minimum 1, failed to provide a meaningful opportunity to request and obtain a reasonable fear screening, the first step to being able to apply for cat protection. Cat protection's international, all right? So this is an international piece. And 2, failed to provide written determinations of the outcome of any reasonable fear screening, thus denying an opportunity for NM and TTP and any other class members to submit motions to reopen with the immigration court within 15 days of any negative reasonable fear determination. So again, this is a situation where we're supposed to have this period of time involved as well. Class counsel has received a copy of the notice of removal issued to NM, notifying him of DHS's intention to remove him to South Sudan. This notice fails to comply with this court's order, as it provides no instruction as to the process to obtain a reasonable fear interview and is only in English. Class member NM has limited English proficiency. TTP and other class members likely received similarly deficient notices. That's a good question, Robin. We don't know. We do not know. This court already has held that defendants' failure to provide notice and a meaningful opportunity to apply for cat protection violates class members' statutory and regulatory rights, as well as their due process rights. Similarly, this court found it necessary to modify the PI to ensure that defendants did not seek to elude their obligations by arranging for other agencies to effectuate removals to third countries from Guantanamo Bay and to enjoin an imminent removal of class members to Libya that would have violated the PI. So this is another situation where we had filings saying, well, you only said the DOD, you didn't say DHS, blah, blah, blah. And we do have a footnote here, footnote 9. Footnote 2 up here. So it says, because the circumstances surrounding the removal of any other potential class members are unknown to class counsel at this time, it's also possible that defendants also failed to provide written notice of the third country removal in their native language and failed to provide counsel with written notice for those class members with immigration counsel. So again, they have no idea who all has been affected. All right. If there's any doubt, the court sees none. The allegedly imminent removals, as reported by the news agencies and as plaintiffs seek to corroborate with class member accounts and public information, would clearly violate this court's order. Accordingly, any third country removal to South Sudan or any other country that fails to comply with the terms laid out by this court's PI is unlawful. All right. So the thing is, and what gets me every time on these cases is you can do what you want to do. You just have to follow the rules. And the problem is, if they follow the rules, they can't do what they want to do. See what I'm saying? How, like, hey, you can do this if you want to do it. But the problem is that they don't even meet the bare minimum requirements in order to be in compliance with the law. So the only way they can do it is illegally, or else it couldn't be done. So that keeps going around and around here. Has a complaint from Venezuela. I'm not surprised. We're going to start seeing these cat complaints all over the place. That's really going to be where we're going to see a lot of the damage. And that was raised by the very first judges dealing with these cases. The very first hearing involving all of this, it was like 5 minutes into the hearing and they were talking about the cat standards. All right, number 2. No, they cannot. That's exactly right. So practical seeker, that's what the cat is. That's what the cat is saying. This is an acronym for words I can't say here, but yes, that's exactly it. Class members NM and TTP have demonstrated they did not receive notice or an opportunity to be heard prior to removal to South Sudan. Class members did not receive sufficient notice of their imminent deportation to South Sudan nor any opportunity to seek cat protection. The notice allegedly provided to NM, where he did not acknowledge receipt, was provided less than 24 hours before his immigration counsel was informed that he already had been removed to South Sudan. Moreover, it was provided exclusively in English, although NM's proficiency in English is limited and he refused to sign. Class member TTP also refused to sign. Finally, the notice includes no information about whether or how he could seek protection based on fear of deportation to South Sudan, a country currently experiencing civil war and which defendants themselves have designated for temporary protected status. As the Supreme Court recently stated, quote, notice roughly 24 hours before removal, devoid of information about how to exercise due process rights to contest that removal, surely does not pass muster. And then citing the AARP case here. Right. Likewise, being told that a person is being deported as they're being placed on a bus carrying out deportation does not pass muster. Because class members NM and TTP have established that DHS did not provide them with notice or the opportunity to present a claim for cat protection, plaintiffs asked this court to order the defendants immediately halt their deportations and the deportations of similarly situated class members, or to the extent they've already been deported, to facilitate the return. Oh my gosh, because we know how well that works out. The immediate return to the United States of NM and TTP and any similarly situated class members. Plaintiffs request the same for all other class members similarly situated who have been deported to South Sudan and/or are facing imminent deportation to South Sudan or any other country without meaningful notice and opportunity to seek cat protections. Right. Number 3, this court has the authority to order the return of NM and TTP and any other class member. Yes, I think you're right, Jean Marie. I think they're definitely testing, but also I think they're just completely incompetent. All right, given that the plane carrying NM and TTP and any other class member has likely departed the United States, this court has the authority to order their return and that of any other class member as part of its inherent equitable authority. Citing this 1979 case, absent the clearest command to the contrary from Congress, federal courts retain their equitable power to issue injunctions in suits over which they have jurisdiction. Citing further case law, holding that court's authority would be entirely inadequate to the purposes for which it was conferred by the Constitution if they did not have the power to enforce their judgments. Okay, the court's equitable authority is especially strong here, where NM and likely TTP and other class members were wrongfully deported without an opportunity to seek protection from deportation to South Sudan in violation of the court's PI. Courts routinely order return or the facilitation of return of individuals wrongly removed. Here, citing case law, describing unlawful deportation in violation of judicial stay and later return pursuant to a court order. Further case law, we are ordering this person's return because his presence is necessary to effectuate judicial relief. Further case law, granting petition for review and ordering return. Ordering return to allow individuals to pursue pending application to adjust status. And then number 3 is a footnote here. Real quick, everyone, to the moderators, how are we doing? Are we okay with the comments on? Are we doing okay in here? I just want to make sure that you are okay. Let me just double check that. So for my moderators, are we doing okay? Oh my goodness gracious. Seems okay. Okay. Thank you. Thank you so much. Appreciate that. Just wanted to check. All right. So we've got footnote 3 here saying we've got dockets 59 here. And then citing other case laws. So they're going over and over and over again. Let me just pull these cases out visually rather than reading them all. In case you're wondering, these are all cases going through jurisdiction here, where jurisdiction is allowed. That's another case, and here's another case. There's another case here. All of these deportations, right? Wow, from all of the circuits here too. So all the circuits, 11th. So all of these cases are basically saying you can, the courts can ask for people to be brought back. And we're in all of the circuits. The First Circuit here, First, Ninth, Seventh Circuit, Third Circuit, Second, 11th, and where's DC? I'm sure DC's in here somewhere. So that's what this is right here. This is a string citation for all of the times people have been removed from the country but had been brought back. Just FYI. In many other cases where DHS initially refused to facilitate return, the agency did so after a complaint was filed in the district court. I'm going to footnote 4 here. Again, citing more cases where they're saying, you know, we want you to bring them back. So it happens. This can happen. This isn't something that's weird and unusual and specific only to this particular presidency. These are situations where it's happened over and over again. All right. If the flight on which class members are being removed is still in the air, this court has the authority to order its return to the United States. And then they're citing the JGG case. Oh my gosh, my heart's breaking, everybody, because this is such a mess. This is just completely bonkers. This is crazy. We're citing the JGG case in another case where they're trying to take people to another country. It's just so reprehensible. Returning persons unlawfully deported is also keeping with congressional instructions that DHS agencies shall leverage all mechanisms provided by current law to facilitate the return to the United States of those whose removal was contrary to law, whose removal order has since been overturned or reopened by judicial order, where the return of an individual would correct error or assist in an ongoing criminal or any other federal, state, tribal, or territorial investigation. Skipping here through the ICE policies and so forth. Here, DHS deported NM and TTP and other class members without providing adequate notice of the deportation to a third country, nor any opportunity to express a fear of persecution. In this situation, granting a preliminary injunction ordering return is similarly warranted. Defendants' failure to provide class members a meaningful opportunity to assert fear is flatly contrary to their own repeated representations to the Supreme Court regarding what due process requires in a situation like this, as well as the specific protections this court outlined in its preliminary injunction order. Here. Oh, we're citing oral transcripts. We love that. This right to due process and to simply receive an opportunity to apply for the protection federal law provides is one the Supreme Court has strongly affirmed in similar contexts, even in recent days. And so that huge hit the administration took out of the AARP case is being cited here, explaining that due process requires adequate notice and time to assert a claim in the context of removal. Return is eminently reasonable and necessary in such a situation, as the Supreme Court recognized in recent weeks. They're citing the Garcia case here, holding that the district court properly required government to facilitate return where an individual was deported in violation of withholding of removal protections. Here, denying the government's request to stay pending the appeal, reaffirming government must actively seek return of erroneously deported non-citizen, especially given the mistakes in the non-citizen's removal. And then we also have the JOP case as well. All of these cases are on the closet docket for anyone who's wondering. Preliminary injunctive relief is necessary to ensure defendants do not unilaterally reject their obligations to NM and TTP with respect to cat protections, citing case law. I'm going to go ahead here. This is out of the Ninth Circuit describing agency interpretation that would allow one party to unilaterally control proceedings as strange because it's unnatural to speak of one litigant withdrawing another's motion. Ooh, that's a good point. Luna case rejecting agency interpretation that could render a statutory right subject to manipulation by the government. Yep, that's another one. This is a huge case. Boumediene case. This is the George W. Bush case where we had the towers situation going on. And they had tried with Congress to invoke the Alien Enemies Act for Guantanamo people, and that was held unconstitutional. All right, so very big case here. To allow the government to cut off Madrigal's statutory right to appeal an adverse decision in this manner simply by removing her before a stay can be issued or ruling on the merits can be obtained strikes us as a perversion of the administrative process. Oh dear. Hopefully I won't get into trouble for saying that word. We shall see, though. Right, where's the line in the sand? Great question, because the sand keeps moving. And the person who's supposed to be putting the line in the sand, we can't figure out who that person is, apparently. All right, so we're quoting them, and then here... rejecting an argument that could allow the government to manipulate the test for determining the scope of habeas corpus provision, holding that absent a clear statement to the contrary, statutes should not be read to place in executive hands authority to remove cases from the judiciary's domain. So that's pretty big here. All right, B, plaintiffs are able to demonstrate irreparable harm absent emergency injunctive relief. And so we're coming down the end here of their arguments. Just FYI, the world's youngest country. Oh, I didn't know that. There we go. Interesting. The world's youngest country, South Sudan, descended into civil war just 2 years after its independence in 2011. A 2018 peace deal, long flawed, finally collapsed this week with the result that defendants are flying NM into a country that's now returning to a full-blown and catastrophic civil war. All right. And then we're citing here, The Guardian. Conditions in South Sudan have long been poor and dangerous, even for the South Sudanese. The country is a source of one of the most significant refugee crises of the African continent, with 2.3 million of its own nationals currently refugees or asylum seekers in neighboring countries, and an additional 2 million internally displaced. Wow, that's a lot. And we're citing here a report out of the UN. Protracted displacement in South Sudan has been fueled by a prolonged civil war, compounded by food insecurity, climate change, and large return movements from the crisis in Sudan, whose own ongoing civil war has driven 640,000 South Sudanese to flee back to South Sudan between April of 2023 and October of 2024. South Sudan also hosts refugee populations, but these are from other African countries, primarily neighboring Sudan, but also some from Ethiopia, the Democratic Republic of the Congo, oh dear, Eritrea, the Central African Republic, Burundi, and Somalia. This is according to the Department of State report. The United Nations mission in South Sudan has documented numerous human rights violations. They're including these bad things involving civilians, conflict-related other bad things, arbitrary arrests and detention, extrajudicial things that are bad, restrictions to fundamental freedoms here. And then they're citing more documentation here. Again, I do need to be careful of my words. Across the country, governmental authorities use summary bad things to punish persons accused of being involved in violent activities or committing crimes, with a spike in extrajudicial things in Warrap State in 2022. Armed actors, including government forces, have done things and burned homes. Well, there were people still inside, apparently. The NSS, the country's intelligence agency, effectively operates outside the law, maintaining its own detention facilities separate from the National Prison Service, where detainees are subject to bad things that would fall under the cat piece here. Thank you, Big Grandma. And I am going to grab a throat lozenge, everybody. And we got a puzzle piece. Here we go. Let's do the puzzle piece. I'm glad they changed the puzzle back, although I just missed that one. Okay, everybody, fingers crossed. Did we get it? Oh, we got it. We got it that time. Okay, yay. All right, here we go. Now we're almost done here, and then we will go and read the response from the government, okay? Because I think it'll be interesting to see what their response is to this, all right? There's two sides to every story. Two sides to every story. Yeah. All right. Let's skip here a little bit. I'm going to skip over some of this because this language is triggering. Here we go. All right. And the last piece. So C, the last element. I think there's a D. Let me double check. I think there should be. Nope, there's just a C because they're combined. All right, the balance of hardships and public interest weighs heavily in their favor. The final two factors for a preliminary injunction, the balance of hardships and public interest, merge when the government is the opposing party. Here, NM and TTP face weighty hardships, deprivation of statutory rights to protections, and removal to a country where he is likely to face imprisonment. Bad things and even other bad things. The balance of hardships tip decidedly in the plaintiff's favor when faced with such a conflict between financial concerns and preventable human suffering. So there's that. Yes, this court has already held that defendant's failure to provide notice and a meaningful opportunity to apply for protection under CAT, again, international law, violates class members' statutory and regulatory rights, as well as their due process rights. And it's always in the public interest to enforce the law because defendants' policy and practice is inconsistent with federal law. The balance of hardships and public interest factors weigh in favor of a preliminary injunction. So they're saying we've got everything that we need in order to show the problem here. This is because it would not be equitable or in the public's interest to allow the government to violate the requirements of federal law, especially when there are no adequate remedies available. Accordingly, the balance of hardships in the public interest overwhelmingly favor injunctive relief to ensure defendants comply with federal law. This court's ruling in honor NM and TTP's statutory and constitutional rights. And here's our conclusion. I was just thinking here, we were talking about like the deals that were made for the tariffs. I'm wondering if this somehow, the international tariff situation has been somehow including taking in people. That could be part of the reason why they're saying, oh, it's, foreign policy, because it's like some kind of tariffs bargain. Like, we'll not mess with your tariffs if you take a certain number of people. Oh my gosh, this is just crazy. Crazy. All right, plaintiffs respectfully ask this court to enjoin and restrain defendants from removing and, if necessary, to order them immediately return NM, TTP, and all other similarly situated class members to South Sudan and any other third country until defendants provide the court and class counsel with evidence that defendants have complied with all the terms of the preliminary injunction. This is so important, everybody. Take this with you, all right? Take this with you. This is so important. They are not saying that you can't do this. They're not saying the government doesn't have the right to do it, or that, the government's bad and those things. They're not saying that. It's very simple what they're saying here. Defendants have not complied with the terms of the preliminary injunction. That's the problem. That's where the violation is. So it's actually quite simple. It doesn't have to be complicated. There were multiple factors. None of them were complied with. Right. And again, friendly reminder that deportation is not a criminal situation. Nobody in detention here is ordered into detention because of a criminal conviction. They are in detention because administratively they meet the requirements to be deported. All right? So make sure you remember that. This is not a criminal case. This is an administrative civil case. You are not allowed to deport someone as punishment for a crime. That's not allowable under our system. You certainly can deport people who have committed crimes, but you may not deport them as punishment for a crime. All right, so remember that. Oh, all right. Here we go. Part 2. I feel like I'm going to need a red pen, but we're going to start in good faith with not a red pen, all right? And we'll see where this takes us. Again, for anyone who had been looking for me over on the tube tonight, this was kind of a breaking news situation. So we're staying here over on the talk in order to get the information out. So, all right, here we go. Right, here we go. This was just filed again. And also another reminder, on the docket, the court has entered a minute entry stating tomorrow at 11 a.m. Eastern will be a hearing to go over this. So there you go. Defendant's opposition to plaintiff's motion for temporary restraining order and preliminary injunction on behalf of OCG. I'm not sure what they're talking about with OCG. Here we go. This court should deny plaintiff OCG's motion for a temporary restraining order and preliminary injunction. OGC? Hold on, because hold on a minute. Oh my gosh, people. All right, we have NM and we have TTP, and then we have anyone who is part of the class. So maybe they're saying the OCG is part of the class? Why are they just picking one person out? And why aren't they responding to NM and TTP? That's a mess. Office of General Counsel. But here it's saying to facilitate OCG's return to the United States. Right? So they're saying returning OCG. Is everybody seeing that? They're sloppy briefers. That's a true story. That's truth right there. All right, so I don't know. This is ridiculous, but maybe it's the teacher in me. I just want to take off points. Okay, -5 points. All right, let's move forward. Plaintiff's request for relief to facilitate OGC's return to the United States is extraordinary in a case arising in district court. For the reasons discussed at length in the government's opposition to plaintiff's motion for preliminary injunctive relief, this court lacks jurisdiction to order defendants to return OCG. Additionally, the procedures OCG received during his removal proceedings comport with any due process requirements, particularly since OGC has already been moved. What? Like, you didn't even take the time to put the right initials in here? Maybe it's in the notes at the bottom. That could very well be. We'll keep going. Has already been removed. Therefore, this court should deny OCG's motion. Here we go. And then we've got footnote number 1. So let's take a look at this. The government recognizes and deeply regrets it completely inadvertent disclosure of OCG's alien number and name on the public docket. Undersigned's counsel for the government took immediate action upon recognizing the inadvertent error and immediately apologized to the court's clerk and counsel for OCG. Oh, so they disclosed the name? What? All right, hold on a minute. Disclosure of alien name. I mean, ACG? I don't know. Because, it's NM and TTP. I mean, are they talking, is this maybe TTP? I mean, is that? No. Office of Consumer Goods. Oh my gosh, that's funny. Right. Yeah, so what I'm trying to do here is I don't want to keep saying a name that shouldn't have been in a document over and over again. You know what I mean? Right. Well, it's got to be one person that they're speaking of. So I'm just going to refer to, no, not Garcia. No. No, Garcia here isn't involved in this. This is Garcia is a different country, different jurisdiction, different removal process. Yeah, is another filing as part of the class. Okay, so it is another person. All right, another person. Okay, so it is this then. It's they've named three different people, three different petition plaintiffs, right? NM, TTP, and any other class member. So what they did, which is, what we kind of thought, they just pulled another class member out, okay? So now we know for sure that there are at least 3 people included in this situation. All right, so we've cleared that up. Kristen, you think they didn't update the initials? Could very well be. And they've done that before. They've absolutely done that before. All right, let's keep on. We'll keep on keeping on here. So next up, standard of review, preliminary injunctions, and extraordinary and drastic remedy. It is in deciding a preliminary injunction motion, and then they go through, that's interesting. The plaintiff's likelihood of success on the merits, potential for irreparable harm in absence of an injunction, whether issuing an injunction will burden the defendants less than denying an injunction would burden the plaintiffs. 4, the effect, if any, on the public interest. That's interesting. Not even looking at the docket, so the attorney... exactly, Navy vet, exactly. Like, this is that element of incompetence. They're just so stinking giddy to try to put people on planes and ship them places that they are just not even, tracking properly. Like, goodness gracious. Okay, here we go. Next, the party seeking the preliminary injunction bears the burden. So their standard of review, I do not trust that it's correct, so I'm going to skip through it. All right, I don't know if their citations are correct or their view of the law is correct. These are supposed to be the winter factors, and this doesn't sound quite right for the winter factors. So we're just going to go forward here. I don't trust that this language is correct at this point because they make so many mistakes. Okay, I got you. Okay, got it. All right, here we go. So here's our arguments. Plaintiff OCG is not likely to succeed on the merits of his claim because this court lacks jurisdiction to order his return. So, wow. All right, so let's break this down just a little bit here because this is what? So the court doesn't have jurisdiction, so the plaintiff's arguments would not be successful. Yeah, okay. That's terribly written. Section 1252G bars review of Section 1250. What? Section. All right. Section 1252G bars review of OGC's claim. Section 1252 of what? Of what? Right? I mean, follow it. Follow it here. Section 1252G bars claims arising from three discrete actions identified in Section 1252G. Of what? Including as relevant here the decision or action to execute removal orders. Congress spoke clearly, emphatically, and repeatedly, providing that no court has jurisdiction over any cause or claim arising from the execution of removal orders. What? Notwithstanding any other provision of law, whether statutory or non-statutory, including habeas mandamus or the All Writs Act of 8 U.S. 1252G. So is this 8 U.S. Code? Is this the All Writs Act up here? Which would be, this is the, oh my gosh. All right. Oh my gosh. Wow. Okay. (1252G) bars claims arising from three discrete actions identified under that section, including the decision or action to execute removal orders. What? Congress spoke clearly, emphatically, and repeatedly, provided that no court has jurisdiction over any cause or claim. Why are we pulling quotes out here? We don't have proper citations at all arising from the execution of removal orders, notwithstanding any other. You can't. All right. You can't just do this. You can't. All right. Okay. Hold on. I gotta get. So this isn't right at all. We can't. Hold on. Let's just. Oh my goodness gracious. Let's just highlight here real quick. All right. We don't want to go too far without acknowledging rubbish. You got to get the rubbish out of the way, or else everything gets all dinged up as rubbish. So let's just pull this sentence apart. Here we go. Everyone's like, hurry up and read it. I just can't. I'm unable to until we pull this sentence apart, this rubbish. All right. And then we'll go in here and we'll say, Congress spoke, no courts, in quotes, any clause or claim, in quotes, notwithstanding any other provision of law, statutory, non-statutory. So this whole sentence has no proper citations. The form is basically like, well, Congress said this, that, and the other, according to us. So this is a trust me, bro sentence. Right. Judicial, right. Exclusive jurisdiction. Right. So you're mixing in. I mean, we've all seen that before. A couple of quotes, that's fine. But for an entire sentence, well, we say this, and then we quote, and we say this, and then we quote. But there's no anchor here. Alina Haba, I was just thinking that. All right, so you can get points off of that. Well, it means nothing. It's like that. Well, this court has already held that it has jurisdiction over legal arguments raised by plaintiffs and issued relief for class members within the United States. It is quite another thing to order the return of an alien whom DHS has already removed pursuant to its statutory third country removal authority at the time plaintiffs filed suit. So this third country removal authority is like what the lawsuit's about. Like, that's a critical piece. Section 1252G is specifically directed at the deconstruction, fragmentation, and hence prolongation of removal proceedings. That's a decent citation. Good for you. Good job. Good job here. See, you put your citation and then you quoted a whole bunch of words connected together. And then you quoted or you cited a case. Now, again, with any of their citations, we don't know if they are correct, because they're incompetent. Ordering the return of OCG is directly contrary to this purpose. All right. So why? Let's ask that. While aliens within the United States have not yet reached the culmination of the removal process, OCG's removal proceeding culminated in his removal from the United States over a month prior to this suit's filing. Ordering his return would deconstruct, fragment, or ultimately prolong his removal from the United States in direct contravention of Section 1252G's purpose. This court should therefore deny his motion. That's a little weak. Let's make sure we understand what their argument is, though, all right? So they're saying his removal proceedings culminated in his removal. So let's just make sure. So we had removal proceedings. His proceedings then said he could be removed. Judge just entered another item in order. Okay. Well, is it the minute order on the hearing, or is it another order? Is it another one? Okay. So, and as we continue to go through that, the thing is like, well, what? Do we have a removal order? If you have a removal order here, that's all you got to do. Let's show the removal. It's a one-pager saying what they have to say tomorrow. All right, hold on. Hold on, everybody. Just a second here. Okay. Let me go print this. Yeah, I was going to say, I mean, they have a hearing set for the 21st, but I was like, are they not meeting today then? Because it's kind of a big deal. Let me go grab it. Okay. All right. Here we go. Here we go. Yes, here we go. We'll pause this for just a moment and take a look at the order here. Maybe this will clarify a few things. Breaking news. Breaking news. Oh, I know. It would be great if we could get these documents in an easy to locate place. We have had that many, many times before. How much is your monthly Pacer bill? Well, I actually do not. I try to not use any documents on Pacer because I want everybody to have access to the documents I'm using. So it's actually not that big. Unless I find something special and just share it. But any original source documents, I try to make sure that they're publicly available for free for everyone. All right. Oh my goodness, VC, yes. And, thanks everybody in the chat here for helping us out. Appreciate that so much, but I'm glad you told me. So we've got an order here. At today's emergency hearing, the court ordered defendants to maintain custody and control of class members currently being removed to South Sudan or to any other third country to ensure the practical feasibility of return if the court finds that such removals were unlawful. While the court leaves the practicalities of compliance to defendants' discretion, defendants have ensured, and the court expects, that class members will be treated humanely. All right, well, the court has further ordered the defendants be prepared for tomorrow's pre-scheduled hearing to identify by name the affected class members and to address, 1, the time and manner and notice of each individual received as to their third country of removal. So that's, again, part of the injunction. And two, what opportunity each individual had to raise a fear-based claim, which again, that's specific legal language regarding the cat, all right? Oh my goodness gracious. Right. In the event that defendants determine that NM is not a class member or was otherwise removed to any country other than South Sudan, defendants must nonetheless be prepared to address the details of his removal, including when and to where he was removed. Ooh, looks like the government's saying that the information about NM is not accurate. The names of individuals personally involved in executing his removal and information currently in defendant's possession regarding his current whereabouts. So what's going to happen, right? They're going to say it's state secrets. They're going to plead out state secrets privilege is what they're going to do. And they're going to say, we're not going to tell you that information because it's state secrets. And then all the judges around the world will just face palm, right? All right, here we go, flipping it over. And then that was so ordered. All right, so there's our update. That's incredibly important as we get ready for tomorrow. And okay, so back in it. We're back into the government's response here. All right, what we're doing, we're down here. They're saying proceedings culminated in his removal from the United States over a month prior to this suit's filing. All right, it'd be great if they could show evidence of that. That would be very helpful. B, section 1252A1 and B9 bar the claim because he had not had the ability to file a statutory motion to reopen from abroad. What? Are they saying he was already in another country? What? This is just bonkers. Unlike other aliens for whom this court found the procedures available in immigration court to be legally insufficient and logistically impossible, effectively foreclosing all meaningful judicial review, plaintiff OCG had several opportunities to have his fear claim into Mexico. Why are we in Mexico? Effectively reviewed. Therefore, his claim is barred by this section here and the Aguilar case, holding that section 1252B9 bars claims that can be raised efficaciously within the administrative proceedings delineated by the INA. And then we have some redacted stuff. Get out of here with that. All right, so it looks like we've got a flipped side. They're saying that numerous district courts have said that they're refusing to return people, and then they set out their set of rules. I know, right? It's short. Their response is short and sloppy. Here we go. Second, unlike other aliens in the class, OCG had an opportunity to file a statutory motion to reopen in the 90 days following his withholding of removal proceedings, which ended in February of 2025. Citing case law, which again, we don't know is accurate, there's no indication that he did so. However, because the opportunity nonetheless existed, his case again differs from the other class members and is barred, which requires that aliens seek relief for their own removal orders through a well-trodden immigration court system. And even still, OCG could file a sua sponte motion to reopen with the immigration court and ultimately obtain review. What? File a sua sponte motion? That doesn't sound right. Oh my gosh, a sua sponte motion. Hold on. Let me double check my definition of sua sponte motion, because that should be a motion on the court itself making that motion. Right, the court on its own initiative. Let's double check. I'm not an immigration attorney, everybody. All right, it can be initiated by an immigration judge rather than the party involved in the case. So that's oh my goodness gracious. Are you freaking kidding me? This is just, So that's wrong. Wrong. Wrong, wrong, wrong. This is just, my goodness. All right. Let's move forward. Let's not get caught up here in the weeds. All right. All right, here we go. Keeping going. Right. Oh my goodness. Right. I'm not. No. All right. So we're skipping here and let's pick up here. Additionally, while plaintiffs point to many courts of appeals decisions ordering the return of aliens to the United States, these cases are distinguishable because 1, the alien was ordered to return in the context of a petition for review, 2, the alien had not been ordered removed, or 3, the removal order was invalid or stayed. This court should therefore deny OCG's motion. Let me just make a comment here. Good if you need to let out the F word. So let me just make a comment, all right? This is just, I'm trying to, the Hulk's won out. But let me just say, if you have a string of citations like they did in here, right? We went through that and I had just highlighted, let me just show you exactly what they're referring to here, all right? Here we go. So they're in footnote 3. These are like a whole bunch of cases from all these different circuits that they're citing to. So they're like, this is this, and this is this, and this is this. And so then the defendant, the government's like, for all of those cases, there's like a dozen cases, and just pick either 1, 2, or 3. 1, 2, or 3 applies to all of those cases. Does it apply to a specific case? Well, we're not going to tell you that. We're just going to tell you that in general, these dozen cases cited as good federal law didn't involve anything. So, like, what? That's an improper argument against case law. You've got to pick your case and say why it's wrong. You can't just put it all together in a sentence. Exactly, custom. All right. I laugh so I don't rage. Here we go. FARA further bars OCG's return. All right, let's take a look at that. As we come down to the end here, independently ordering the return of OCG would violate whatever of the FA Reform and Restructuring Act. So this is the FARA, which implements Article 3 of the CAT. Can't use those words. It provides that, quote, notwithstanding any other provision of law and except as provided by regulation, no court shall have jurisdiction to review the regulations adopted to implement this section. And nothing in this section shall be construed as providing any court jurisdiction to consider review claims raised under the convention or this section. So, okay, so if there is a CAT issue, they're saying here the courts have no jurisdiction to review the regulations. That's different than reviewing the case. If they're going to come in and say the CAT law isn't okay, maybe they can't do that because it's got international pieces to it. But to say whether the case is okay or there was compliance with the regulation, like that's the court's dang job. You know what I'm saying? That's what the court does. All right, moving on. OCG's motion requests that defendants facilitate his return to the United States to implement the CAT via additional and different procedures beyond those adopted in DHS's implementing regulations. They have implementing regulations, everybody. Indeed, this court has seemingly recognized that the CAT regulations do not demand the relief plaintiffs seek and instead has held that the Due Process Clause requires further procedures. But no court, and certainly not the district court, oh, that's not very nice. Don't do that. Don't demean your court that you're filing to people, has jurisdiction to review DHS's implementation of CAT. That's not correct in order further procedures. Yet that is precisely what this court would do here by ordering the return of OCG. Oh my gosh, they would mandate how CAT must be implemented in the context of OCG's third country removal. That's what this whole case is about. The whole case is whether or not you can send people to a third country. I feel like they didn't read the petition. Yeah, right. All right. Therefore, this statute is fatal. Whatever. 2, plaintiff lacks any statutory, regulatory, or due process right to the procedures he seeks. All right, let's take a look. Here we go. Prison Barbie? No. Oh my gosh. I was just thinking that. Like in every box of rules is a little tiny like ice Barbie. Like, what are we doing here? What's even happening? This is madness. Who are these people flying these planes? Listen up, pilots. I got something to say to you. You're making all this crap possible. All right, here we go. Finally, as this court seemingly recognizes, there is no statute or regulation requiring the return. What? There's no statute requiring the return, just a court order for DHS to provide additional removal proceedings. Defendants maintain that OCG have received all process to which he's due. Do you have any proof of that? Can we see some proof or not? No proof? Due process does not require an additional round of proceedings after the final order of removal. Could we see the final order of removal? Is that possible? Especially for OCG, who was never admitted to the United States. We don't have any proof of that. We have no evidence. We don't even know who OCG is, quite frankly. And then they're citing cases. Again, I hesitate to read through their citations because sometimes they're wrong. So there you go. Moving forward here. Additionally, plaintiff OCG admits he was notified of his removal to Mexico. Okay, given OCG's declaration and the myriad of process he was provided in his removal proceedings, he fails to establish that the due process clause demands his return to the United States. How is his, and that's not a correct citation either. So we're gonna take points off for that one as well. I think we're about to get attorney. No, VC, no. If you received this brief, would you be surprised? I would feel, if I was a judge and I received this, I would be like, that's an hour of my life I'll never get back. And shame on them, because this is rubbish. Again, if you follow the rules. But if you're going to just, cut and paste stuff together, like, it's so clear that these people do not have experience in court. It's just so clear. All right, here we go. The remaining preliminary injunction factors do not favor the plaintiffs. When a movement fails to establish that he's likely to succeed on the merits, the remaining preliminary injunction factors become matters of idle curiosity, because for some reason that quote's important. As explained above, OCG is not likely to succeed on the merits of their claims. Consequently, he's not entitled to preliminary relief regardless of other preliminary injunction factors. Okay. So for the foregoing reasons, the court should deny plaintiff's motion for temporary restraining order and preliminary injunctive relief. Okay. And then over here, oh my gosh, this Yakov fella. This fella is in like a lot of this stuff. He's signing a lot of this stuff. I don't know who this fella is. I'm not going to say anything negative about him, but I will say he's involved in a lot of this stuff. Okay. So at the end of this, they're saying that OCG is not entitled to a restraining order for, reasons or preliminary injunction. Okay, fine. What about NM and TTP and the rest of the class? What about that? Because that's the actual question presented in the motion. These two people specifically identified, and the rest of the class. So they're saying, well, one person in the class, there might be some questions about if they can dig up the official deportation order, which you go for it. What about the rest of the class? Because there's 20 people on the plane? What about everybody else? And what about these two specifically named? So this is a moment where it's like, they wrote a motion and they set out specifics in the motion, and they're like, whatever, we're going to just go down our own road, because none of this stuff is applicable to either of the named petitioners or the rest of the class. This is specific. This opposition is specific to one person. So it's not even a fully fleshed out response. Yeah, Mexico. So, because I think he's from, I feel like it's a different response. Oh my gosh. Right, right. So that's the issue though, isn't it? I mean, I thought he was from Mexico. But we don't know. Let me go back here to the intro. Let's just see. Let's make sure we understand here. Received during his removal proceedings. Right, they're fine. So should deny the motion. Well, what country again? Let's go back in here. Let's take a peek. There's just so much rubbish. It's hard to figure this out. Here. Removal, right. Not that. Okay, so right. Right, Myanmar. I don't think OCG is from Myanmar. That's the problem. Now, NM, right? NM and TTP are Myanmar. I'm so sorry. Myanmar and Vietnam. All right, so we've got Myanmar and Vietnam. And this one, I thought he was from Burma. The other two. One was from right. From Mexico. Yes. So that's what I was thinking. Hold on. Let's look through here. Let's see. Because now we've got 3 other countries, all of which are not South Sudan. So let's double check here. Here we go. 3rd country. I'm looking here to see where this one's from here. Here we go. Okay. Plaintiff had several opportunities to have his fear claim to Mexico effectively reviewed. Okay, so he was afraid of being taken to Mexico. What? That's not South Sudan. Are you freaking kidding me with this? Oh my gosh. Are you freaking kidding? Oh my gosh. Oh my goodness gracious. So, who said anybody's going to Mexico? Who's going to Mexico? Oh my gosh. Myanmar. Okay, thank you. Myanmar. Yeah, Carol, that's what I'm saying. Oh my goodness gracious. All right, so nowhere in the original motion did they say, and some fella got taken to Mexico. No, nobody said that. This is South Sudan. Originally, we thought South Africa, but that email was pulled, as we all saw. So now we're talking about South Sudan. We're not talking about Mexico. We're talking about South Sudan. Oh my goodness gracious. Goodness gracious. Oh my gosh, yes. So the yak off. Yeah, actually, he was the one I used the example when I was filming how to file an ethics complaint about attorneys. I used him as an example, but I have to go through and refilm that. There are some weird rules coming out tomorrow here on the talk, so I gotta be careful. At the end, they said the court said he was ordered to Mexico. Well, right. But who? So I mean, they're talking about South Sudan here. They're not talking about the Mexico. Oh my goodness gracious. Goodness gracious. Goodness gracious. This is so ridiculous. Here we go. All right. Keep the thoughts inside your head. Okay, I'm going to be quiet inside my head now. We're finding quiet in our head. Can't find the government response anywhere. Oh, did they revoke it? That would be great. If they pulled it. The new rules, saw a video, wanted to read them myself. Yes, so you can go into the, oh my gosh, what are the steps? Hold on. I have the Winters test in my head, so let me think about it. You go into like Creator Studio, and then you go into terms of use, and then it'll say effective as of whatever. And then you go through each one. You can do that in the community guidelines, and you can do that under the terms and conditions is another piece. And then the creator rewards program also, and that's where a lot of the changes are going to be in there. So if you just click on that, then it expands it. Up to date, yes, doing my best. Yes, strong words, strong words. Oh my goodness. All right, all right. So, okay. Okay. All right. So we've got here, and I see it now. I see the OCG up here, right? And again, the people named here, we have NM and TTP. Those are the ones specifically named in the declarations. All right. So that's what we're dealing with. I don't know what's going to happen, everybody. I mean, this is bonkers. You know, you do it once, you apologize, like whoopsie doos, we're sorry. You do it twice, you're still apologizing. You keep doing it, and I mean, this, what? Like, I just don't even know. I know I need a whole video. I have to be careful. I have to be careful right now because there's stuff going down here on the dock. There's some stuff going down. Gotta be careful. All together to learn. Yes, of course, Willie B. Oh, I'm so glad you're here. And I'm so thankful that you all come and hang out with me because it reminds me that, this is information. It's upsetting, but yet it's part of a process. And we just put one foot in front of the other and we keep going down the road until we can see what's going to happen here. But this is awful. This is a terrible situation. I will be very anxious to hear what happens at the hearing tomorrow and also see what kind of action the judge is going to make. We've got 3 judges now. We've got Judge Murphy, we've got the DC Chief Justice, and then we've got, I always say her name wrong. Is it Zinus? We have 3 judges now that are like, you're out of your mind. We need nails and pens video. Oh, I should do that, shouldn't I? Yeah, that'd be fun. I should do that. I was thinking of doing a rings one. I've got a few new rings. I should do that. We should have a palette cleanser. Yes, thank you so much, French Irish girl. Zinus. Yes. And the rings. And adult beverages from Dodge. Oh my goodness. I tell you what, Navy vet. I know. Need the ICC now. I don't know. They got stuff going on. Apparently there's a war going on in South Sudan. There's a lot of stuff. There's a lot of stuff going on. Everything coming. Oh, I know. And that's the thing. And I was saying this earlier today. I had done a live earlier this morning and I was reading through Marco Polo's declaration that he did, not just in the current case that they're working on, but also in the JGG case. And the big thing going through and reading it is like, the justice system's like a giant tank. It moves slow, but it gets you eventually. So everything will get sorted out. It just takes some time. Marco Polo. Did I say Marco Polo? Oh my gosh. Before he even started the live, I was like, don't call him Marco Polo. Sorry about that. Sorry. Right. All I think of with him is like when he had to go to the side and get some water to drink during one of the whatevers after the big convention. I'm in Kentucky. I can sip bourbon. Oh, we love it. Oh my goodness gracious. Yeah, there's some harm. There's some significant harm going on out there. And so I think that the plaintiffs raised a good point. Like they're struggling in their country with their people. The poor people caught up in this civil war are struggling for placement. So why are we bringing more people in for placement when, their own country is just desperately in need of that stability? So it's a lot. It's a lot going on. Oh, you're welcome, Big Grandma. Thank you so much. Yes, and the moderators as well. Oh, so thankful for all of you. So as we kind of, come down after going through some really awful information, just again, we got to keep our chin up. I think it's okay to, I'm going to have to go rage for a little while. I'm going to rage against the machine for a little bit. But also, I've got to I've got to believe that something will be done. And it has been done in all of the cases. Is it as good as what we would like? Probably not. But we still continue to go forward. And, we will see how this unfolds. So I will keep you all posted on what's going on in this case. And thank you all for helping me keep up to date. And VC, thank you so much for even, we were able to pull orders just right off the docket, even during the live. So that's so incredibly helpful. So I'm very thankful to everyone who was coming in and hanging out. I wish you the best of nights. Again, apologies to my tube community for staying over here on the talk, but we just had a lot of stuff going on here. So take care of yourselves, everybody. I will be back again very soon. And I'll keep you posted as this case goes on and develops further. So take care of yourselves.